Bernice gets the lead.
We're all set, Jackie, thanks.
All right, good evening. This is a special meeting of Livingston's Planning Board, and notice of this meeting has been distributed in compliance with the Open Public Meetings Act.
And if you can please call the roll.
Mr. Ratner? Here. Mr. Lewis? He's present. Mr. Dufford? Here. Mr. Batani?
Here.
Ms. Vishnu? Ms. Vishnu?
Here.
Ms. Khanna?
Here.
Vice Chair Santola?
Here.
Chairman Fernandez?
Here.
We have our quorum, we have our board attorney. Member Reber, Diner, and Fass are not present this evening.
Thank you. And if you can please call the first matter.
That matter scheduled for this evening is a resolution amendment for application number 2023-1-MSUB V23 Harvest Lane.
Thank you, and welcome. And just to go through the general procedure for tonight's hearing, the applicant is represented by an attorney who will explain the application. The applicant will call one or more witnesses to give sworn testimony in support of the application, and members of the board may ask questions when the attorney for the applicant has no more questions. When all the applicant's witnesses have testified, if there is any entity or group appearing in favor of or support of the application, may call witnesses. And when all the witnesses have been heard, members of the public may make sworn statements. In reaching its decision, the board may only consider sworn testimony, evidence introduced as part of the record. Is there anyone here other than the applicant wishing to enter a formal appearance?
Good evening, everyone. My name is Matthew Posada. I'm from the law firm Sills, Cummins & Gross, and I represent the developer of the subject site, Rodak Builders. Thank you.
Thank you, Mr. Posada. And Mr. Skolnick, you're welcome to enter your appearance.
Thank you, Richard Skolnick. I have my own law firm in Millburn on...
Your mic's not on.
There you go.
Thank you. Richard Skolnick. I have my own law firm in Millburn, and I'm representing Bargov and Rashi Modi, who reside at 23 Harvest Lane, as well as Tarun and Aditi Soni, who reside at 25 Harvest Lane.
Thank you. And you can, if you wish, make an opening statement. Call your first witness.
I do. Thank you, Chairman. The properties are identified as Block 4001, lots 1501 and 1502 on the tax maps. These properties were before all of you in March of 2023. to bring us back into it. At that time, the board approved a subdivision to create 2 new building lots. It was formerly Lot 15, went into lots 15.01 and 15.02. The resolution was memorialized on May 5th of 2023. And that resolution had a condition of approval that no home on either of the 2 lots exceed the habitable floor area or the permitted floor area ratio in the zone. We respect that process, and we respect the conditions of approval that were part of the board's deliberation. We're here tonight, however, seeking the elimination of that condition that was attached to the resolution on both the maximum floor area and floor area ratio, based upon some very unusual circumstances that we'll go through. This is an incredibly difficult situation for my clients who were innocent purchasers of the 2 homes that were constructed and facing these condition in the resolution. I've been a zoning lawyer in New Jersey for a little bit over 35 years now, and I must say, I've never seen anything exactly like this situation. You had that subdivision from May of 2023. It was perfected by deed a couple of months later, July 18th of 2023, and then the homes were constructed by a builder named Rodak Builders Livingston 3, LLC. Certificates of occupancy were issued for both of those homes on July 17th of 2024, and the Sonys closed on 25 Harvest Lane that same day, July 17, 2024, and the Modis closed about 10 days later on 23 Harvest Lane. Both families moved into the homes shortly thereafter with their children and families. And what I'd like to do now is call a witness, a planner, Alex Doherty, to go through in a little more detail with some plans and drawings what has occurred here, what was submitted by the builder, what was approved by the construction department, and what was actually built, and go into a little more detail about what my clients are facing. I thought it'd be good to do with a visual presentation and give the board a little context. So we'll call Alex Doherty, a professional planner.
You swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, give us your full name and spell the last name for the record.
Alexander Dougherty, last name is Dougherty, professional planner. My education at Rutgers Blousing with a master's in city and regional planning, concentration in development and redevelopment, certification of public policy. I'm a professional planner. I testify in this capacity on a weekly and daily basis. I'm a member of the APA New Jersey, professional development officer. I present the League of Municipalities, State Redevelopment Conference. I'm also the principal planner for the town of Dover. My licenses are current and good standing.
Chairman, I'd submit Mr. Doherty as an expert in the field of planning.
Are there any questions or objections from the board? No, so the board accepts you as an expert witness in planning.
Thank you.
Okay, Alex, you presented a slide presentation tonight, which we'll call A1. How many sheets do you have altogether?
It's 13. I don't know if we'll need to go through all of them. It consists of maps and photographs. Slide 1 is the property in question prior to the subdivision outlined in red. This was prepared by NJDEP's GeoWeb. Just gives a little context of the size of what the subdivision was. Oversized, and the properties in question as well are oversized lots. Slide 2 is a reflection of what is out there today, the built environment. These are drones taken May 26th by myself at the subject site. Beautiful homes, good architectural design, really great curb appeal here. To the left, we have 23 Harvest, and to the right, we have 25. So this first slide here on page 3 is from an open request done by the applicant and council. And pursuit of looking for the approved plans that this board otherwise can, as you've, were open remarks, per resolution, condition not to be over the habitable floor area and habitable floor area ratio. Upon that request, we were able to, through Oprah, get the architectural set of plans through the tax assessor's office. So in the red, top left, it's hard to see, so I put a red arrow. This identifies 25 harvests, and the red arrow on the bottom is stamped with the tax, I guess, rubber stamp, ink stamp. So this is architectural layouts from Space and Mark LLC. This was dated 7/28 of 2023. This is the cover sheet of 10 for 25 harvests, again, from the tax assessor's office. The next slide here, I just want to stay on this slide for a second. The bottom two images are from that slide deck. They're cropped out and put side by side. The top two architectural plans are what 23 harvests presented architecturally to the zoning board, which ended up here for that watermark for the resolution that FARs could not be requested. What's important with this slide is, from our understanding, what was presented to the town, what's on file with the tax assessor. What's important distinction here are these red arrows on the bottom here. This is where the roof line is, I guess, supposed to stop. Up here in red is approximately illustrative, this, for illustration purposes, where that would fall if we see the middle architectural bead in the house here, as here. And the blue arrows are currently existing here today, where that roof line is. This is important because as FAR is habitable floor area ratio, the bottom two images would otherwise have met the compliance. What we have here, unique, I will echo council's concerns. This is a very unique one-off situation. I have never seen FAR requested from an applicant for second floor space. It's typically from a planning perspective, and I'm out every night, daily, weekly. I always end up requesting FAR for an addition or utilizing an attic space that would otherwise would be finished and account towards that FAR. And in some rare cases, garages and basements, depending on the township I'm before their definition. Never have I ever seen an existing building footprint on the second floor and an applicant requesting that. So I was curious and I went to the property. The next couple slides will show exactly what is the concern from the applicant and why we're here requesting the planning board to rescind that resolution. I think we have a unique situation.
So to your understanding, there was a roof line submitted by the applicant and approved by the construction department?
Correct. From my understanding, through Oprah's, we weren't able to get that plan from the construction department, but however, we were able to get that architectural plan through the tax assessor's office, which was the prior exhibit here. This is the cover sheet, and then these two images are cropped out from that, so I can blow them up and put them side by side. But council, correct. This is my understanding was the proposed plan for project that would otherwise be reflective of the design and scale of the bottom two images. Again, the upper two images reflect the current conditions from an architectural standpoint. So the next couple slides really just bring the drone out, give you a feel for the size and neighborhood, the character here. For purposes of orientation, we're going to be referring to the back of the property, that kind of small step down. So the back here, this window and the other window on the side, this is the space that otherwise, from my understanding, was not on the original plans to be built. So we take the drone out. I want to point out, from perspective of this FAR that we're requesting the board to rescind from the resolution. We have ample space all around us. It's kind of a very unique dead end back here on Harvest Lane, where the two properties really are kind of by themselves.
And Alex, just to clarify the relief, we're not asking this board to grant an FAR variance or a habitable floor area variance.
We are not. We're hoping that if the board sees it, we can ask the zoning board to hear our concerns, and we can hopefully put testimony on what that case law is about. But for purposes of FAR, we're just asking for now, just to consider the opportunity to have that discussion at the zoning board. But we can't until that is removed from
I
resolution.
think all the members are clear. I just want to make sure on that point, right? There was a planning board resolution when the subdivision, the homes, the individual homes were not shown to the planning board. The planning board considered the matter and said, we'll grant the subdivision, but you're not allowed to go back to the Board of Adjustment for the FAR or the habitable floor area.
Yeah, so the only thing before the board really is just to, whether we're going to remove that condition. Because one of the things
Sort of
that, whenever these things come before us, the concern of this board is always that after somebody leaves here, that they're then going to run to the Board of Adjustments and then seek a variance. And that's something that the board, looks really unfavorably on.
We appreciate that, and I tried to address that in my opening by saying my clients, they're we believe to be the innocent purchasers here. They had an experienced builder who built something that wasn't on the plans, and somehow it made it through, and certificates of occupancy were issued. My clients, they could testify, but I think it's somewhat self-evident, that they did not understand this process. They had a situation that Alex is going to show you in a second, where there's this extra space of 600 square feet that is shown, that is over the floor area, either the straight standard of 3220 for the R4, or brings them over the FAR. So tonight's request is to eliminate that one condition in the planning board resolution, and then it would be up to the applicant, the individual homeowners, to then go back to the Board of Adjustment to sort of make those proofs, and we'll just have to see what the Board of Adjustment does. But right, they had tried to do that. Mr. Modi had gone to the Board of Adjustment because that's what he was told to do, go to the Board of Adjustment to get approval for this extra 600. The board's counsel, I think rightly said, we don't have jurisdiction. There's a sort of like a title defect because the planning board resolution prohibited that application. So I just want to make sure everybody, we have a very unique circumstance here. And I just want to be clear about what the relief is. And, here to state, Chairman, this is not the case of a homeowner building too much or not building. It's an innocent purchaser was presented with a set of circumstances. So Alex, if you could sort of go into a little more detail about
Certainly.
What we have here.
So what we have are two beautiful homes, but outlined in red. They're illustrative purposes here. I put that red in here. It's approximately this area in red, and as well as 25 Harvest, because I'm in the backyard here on 23, 25 as well. Guesstimate, visually, just representation here. This area is the area in question and discussion that currently exists on at site today, where, as we recall on the slide 4, that roof line was a lot lower, and it was about in the middle of the building. So at my office, I have multiple screens, so I had that up, and I was trying to be as accurate as I could on where this would land. But generally speaking, the idea was the rear of the house, from my understanding of the architectural drawings, that second floor that you see here, there was that step down, if you will, so that would otherwise be, trying to reflect that in this red here. Does this equate to it exactly? I don't believe so.
So is that a full second floor now?
Yes.
Okay.
So from a planning standpoint, when I go for FARs, I very rarely ask for FAR on the second floor of an existing 4 walls of a building. So what you see here is the interior. On the left side is going to be 23 Harvest. On the right side is going to be 25 Harvest. They're mirrored homes, and they're impressive homes, beautiful homes. I'm on the second floor. I'm looking straight ahead. What I want to point out is when we look back here, there's no windows on these back walls, and it's the same here. The center's the bathroom, and bedrooms and the laundry rooms. So what we do is we pull down the attic, pull down. I'm in the attic. So we can see on the bottom left, there's some light. On the right, I don't know what you would call this here. The roof line here seems to be a little bit lower, but we're in the attic on the bottom two. Again, 23, 25 Harvest. These were taken on the 26th of May. I'm in.
Climbed into the attic.
I
and
climbed
then-
in the
And then you
attic.
climbed back down behind those rooms.
So this is that dead void that were at the zoning board trying to discuss, where they brought us back here. This space exists. This is that FAR that we were having that discussion
And the
with.
stairs going into there are they're pull-down stairs?
Yeah, I got up there through the attic, and I walked in, and I basically just dropped down in the back of this large void. So this is
How'd
where,
you get from the attic down into this space? Did you have to jump? Or is there another pull-down stairs?
I dropped in, I grabbed the rafters and just dropped
Dropped in like?
Drop
And
down.
then after the CO, those things are then removed and full stairs are put in?
There's no stairs here.
Yeah.
I went into the attic, walked in, dropped down.
Okay.
This is sealed off.
Okay.
But that's not code. How did they get?
I'm not a construction official. I can't speak to the code, but that was one of the concerns, from my understanding, that both property owners have concerns. We'll go through it. There's HVAC back there. There's a window you can't access. There's wires back there. I don't want to speak too much on what is code, what's not code, as I'm not a construction official. I don't know the UCC code book, but that was a concern I had.
Let's all agree you can't have a room you can't get in or out of.
So we're here. This
just
is
to
the
be
void
clear,
in the
The
back.
CO was issued for this home.
The two spaces in both houses are currently, that's what they look like now? They're not finished?
Correct. This
not
is
sheetrock, not-
how they exist today.
Okay.
And from my understanding, both homeowners had never been back there. The fact that I dropped down in there, they're like, "Whoa, what's back there? What do you see? Is there, treasures or a note?" No, there's not. There's.
Have you come as part of your, learning about this, why this was like built as just a separate panic room?
All I know is I've been on job sites. I used to do electrical work. I've, worked on HVAC and worked on plumbing. Things happen in the field. That's why we have as-bills. That's why we do the inspections. I can't tell you how that got there. All I can tell you is it's here.
How do they get access to it now?
They don't. Through the attic, if you want to walk in the attic and drop in.
So my assumption is at some point, this was discovered. I'm guessing they must have got either TCO or CO for every place but this space. And ultimately, this space will connect to the second floor of the whole house, I'm assuming.
From my
If it gets
understanding,
approved, the intent would be to,
23 Harvest attempted that, and it was flagged, as it should have, by the zoning officials and construction officials, that, hey, accessing this space would otherwise bring you over FAR. And that's when I was contacted to say, hey, I need an FAR variance, and unbeknownst to this whole thing, and now I'm here before the board, the planning board. So I've never seen anything like this, and things happen, but all I can say from a planning standpoint, I know, council, this is not the zoning board, I'm confident in my abilities to discuss FAR to zoning board with this current condition. It's about scale, size, and massing, and as a level of control. That scale, size, and massing exists there today. So we are going to ask the zoning board to utilize that. It's not the attic, the basement. We're not asking for additions on the second floor. And rightfully so, they brought us back to the planning board for resolution.
Can you just show the backyard and the?
Certainly.
Again, we're
Wait,
not
wait,
here to make.
before we leave that, if, I know you're not here for the FAR variance, but if you were to get the FAR variance, is there like a conceivable way that this connects to the rest of the second floor? Is there like a cutout waiting to happen?
So I believe, no, there's no cutout waiting to happen. And reviewing 23 Harvest's application before the zoning board, the idea would be to basically remove this bathroom and do a hallway and kind of access it that way, and then move the bathroom off to the side. It was just a matter of basically going straight forward here and going back there.
I
It's
think
just a wall.
Mr. Lewis had it right. There's gonna have to be some renovations on there.
Interior reprogramming of the second floor to access that space, but it's just a matter of knocking down a wall and continuing the hallway through the bathroom
Well,
area.
to me, it kind of senses, not to prejudge this, but it seems less sinister that you would have to go through all this trouble to use the space, whereas if there had been a pre-cut out door jamb that you could just pop through the sheetrock, then this could have all been premeditated, exactly.
Yeah, we're not saying it was premeditated.
No, I'm not saying,
No.
I'm saying what
You-
we're
when you're
looking at, we're trying to figure out, what happened here, and I don't know that Mr. Rodak would build a house, we have to demo the bathroom to be able to get to this back space, that's awfully,
I have a couple properties myself. I brought property's down to studs, do full renovations, I think that renovation would have been fairly minor to access that additional 200 some odd square feet of habitable space. But,
200 or 6?
sorry, it was close,
600.
600 square feet of
And on the
additional
plans
space.
you Oprah'd, that doesn't exist at all. The roof is just lower.
Right, so I believe the initial design was this is where I was, that void back there, those were those windows that nobody has access to. That roof line was, from my understanding, supposed to be substantially lower. So
Right.
that rear portion of the second floor doesn't extend as it does in the current plan. The top two images are what's there today. The bottom image, from my understanding, was what was supposed to be
And
constructed.
is that a great room in the back? On
Yeah.
the first floor?
Yeah, so yeah, it would basically just, the second floor kind of stops, and the first floor continues a little bit further past that. Here, the second floor basically continues over the first floor, which was not, from my understanding, what was supposed to be constructed. Constructing it as it exists today is kind of why we're here. That space exists on the second floor, not the attic, the basement, it's not an addition, it exists there today.
I'm just confused about one thing.
Yes.
Sorry, yeah. When the house was constructed this way, there's no access to that area. When the house was purchased, what was that area marked as? You know, you buy a 3-bedroom, 4-bedroom house, and, you know, we walk through each room.
I don't believe I'm at liberty to discuss that. I'm not the purchaser, I wasn't part of that walkthrough, part of those negotiations and understanding of purchase and acquisition of the site. But from my understanding, that's something maybe the council or the applicants can discuss before the board for some additional information.
Could have Mr. Modi, you know, they had an understanding that at some point it could be fit out. They didn't understand even what zoning was, so we can bring him up.
So there was a understanding of some sort that it could be used eventually.
They knew the space was there. I'm proffering for you because my client is right
Right.
here. They knew the space was there, and they had a lot of conversations with the builder about potentially building that out. Ultimately, they made the application, they were told, oh, you'll need to go to the Board of Adjustment for the FAR and the objective habitable floor area. They knew the room was there, but they had no knowledge, why would they, that
It wasn't supposed to be there.
you would need a variance, and that there was a resolution that said you couldn't apply for that variance.
Right.
That's the big missing piece, and why I suggest to you that my clients are very innocent purchasers. They knew that the space was there. There was wiring. Alex, can you show it, right?
Yeah.
It was wired. It's nice space. They anticipated at some point trying to build that out. They thought they'd just have to go to the building department and get the permits. And then, surprise, you're not allowed to do it, and now you have a structure with this very unusual condition. And again, we're suggesting more building plans. Builder presented something that was approved. The builder delivers the CO to them. So now it's closing day, right? Mr. Santola said, you know, the COs were issued on July 17th, 2024. One of my clients closes that day. One of my clients closes 10 days later. But how are they to know, you know, that there's, so we're here to, in a reasonable way, ask this board for the permission to go to the Board of Adjustment to present the case. We're not asking you to decide on the FAR.
Of course,
I'm
that's
repeating
not our
myself,
purview.
but I just want to make that point. Alex,
So-
could you
so
show
this-
the
so this was-
backyard for a second?
So this was marketed as a livable space.
I put my client on to say, but that to me is self-evident. It was wired back there.
Wasn't sheetrock or anything else.
There's a 600 square foot space but on the second floor. But that's for a different forum. That's a dispute between my clients and the builder potentially. And we're hopeful that if this can be resolved through the requests we're making tonight, and then ultimately at the Board of Adjustment, that dispute will be fairly narrow and sort of manageable. If that doesn't happen, it gets a lot more complex, because then it's what to do with this space, and the house is different. So, Alex, how about the aerial? And
Yes.
the point I'm trying to make is, we're not asking the board for the variance, but the board had concerns. We know the board had concerns when they came to you for the planning board approval, and you said no FAR. Oh, and the point I'm just trying to put forward in front of the board is that there's these very large backyards. So we're not here to establish detriment like we would for a variance, but
So, yeah,
we don't think any member of the public is gonna know the difference between what the construction department approved and what was actually constructed. Because there's a, right, we have a very large backyard, and we're talking about the FAR goes to the massing of it's only in the back, of course. It's only in the back, the extra massing of this 600, and there's a massive back. Show us the area.
Yeah, so on slide 1 here, this map from NJD Appeal Web, for those that know, Livingston all that well, there's a bank next door off to the side. That bank has a little finger that kind of creeps in the back behind these houses. So this property does not abut the other residential property. So when we say a massive backyard, though, these are 2 subdivided lots that are oversized lots, but also we have a large void in the middle from the bank's property that's, wooded, and then we have the neighbors in their backyard. So there's an area right here on this lot that kind of extends behind that, and that's kind of really reflective right here, this large void. So we have...
Oh, that's bank-owned property there?
Yes, that's bank-owned property.
Okay,
That's part
so
of their lot.
But you have a considerable distance
Yes.
with a good bit of trees to the houses in the back.
Correct.
They're the ones that the Board of Adjustment presumably is gonna have to decide, is their air, light, and open space negatively impacted? And our suggestion is they're pretty far back. There's a lot of trees. The folks who live back there are never gonna know.
Is the footprint as built the same as was submitted on the plan?
I don't believe I can answer that. I don't believe I saw an as-built.
Footprint?
The
Footprint?
Well, the footprint, yes, the 4 walls are, from my understanding...
Footprint, yeah, it's just
Yeah.
it's just
Yes.
a vertical. It's the, there was a roof line, and the roof line somehow got built a lot higher, making that space potentially habitable.
But there is a substantial void between the 2 properties, the rear properties of the abutting neighbors' residential properties. It's a very, I think it's a unique corner right here in Harvest. It's almost like it's its own little neighborhood back there with the way the closest neighbor faces. He's kind of orientated away from it. It's just kind of these houses are just on their own in a dead end, if you will, and really. To the council's point, if there ever was an opportunity to have this discussion further, if the board sees it fit at the zoning board, this is just a reprogramming of the interior second floor. It's a pretty straightforward application at the zoning board, but nonetheless, in order to get there, we need the planning board to see the issues at hand and ask for that resolution condition to be rescinded to give us the opportunity to have that discussion of what FAR is and what it means to these 2 properties in this neighborhood. But the building exists there today. With that void, whether it's being used or not, that size and scale of massing is out here.
Could I ask, and obviously the reason, and you said these are oversized lots, but just to be clear, they're, I guess, arguably oversized as compared to some of the other neighborhood lots. They were in fact undersized under the code because of the amount of square footage within the first 125 feet, which is what gave us the jurisdiction to impose this condition in the first place. So I appreciate Mr. Skolnick indicating from the beginning that you accept the validity of the condition. Just for order of magnitude, do you have available what the current FAR would be versus, I think it's 30% and 3250, what are we?
If we were to occupy that space...
Is every square foot of that space over? I mean, is the rest of the house built all the way up to the max?
Yes.
Pretty much, yeah.
Yes.
Okay.
So it's gonna kick us to about 36%, permitted 30. But it's 600 square feet, this back, so in terms of a way to think about it.
Just for purpose of our record, and even though I understand this is not the variance hearing, because if we grant you relief, you'd be in front of the Board of Adjustment, but being that you're a planner here, do you have any opinion in terms of the impact of that enclosed, having that second floor on the,
So-
generally the overall neighborhood detriment, et
So,
cetera?
just a high gloss review for FAR. We typically see in commercial, think of Targets, where, Walmarts, that kind of ordeal. Residential, when it's applied, really is about preventing parachute McMansons, being appropriate scale, neighborhood continuity and conformity. FAR, when we look at it, can the site accommodate the additional floor area? And the answer is
That's
yes.
the legal standard,
Yeah,
right?
the answer is
Coming from
yes. Do we
Coventry
have
Square and
parking?
all
Yeah,
that.
right, we
Can
have-
the site accommodate?
I was given the high
deviation?
I was given the
Okay.
high over gloss review of FAR. Can the site accommodate the additional
Gotta
floor
show the
area?
board that I know the legal standard, Alex.
Do we have parking? If they were to be bedrooms or, expand the bedroom footprints, we would look at, can that site accommodate that? We have water, sewer, the homes are built. Is there gonna be any detriment by way of scale, massing of the building? I would argue not. They're kind of on an island by themselves. They're already built here. I think it's just we would argue certainly more efficient use of land in that regards, purpose A, being able to finish that work that's back there, that kind of stuff. But it does not change the built environment. It's to the rear. You have that beautiful curb appeal. Again, that scale and massing is already existing in the rear. So from a planning standpoint, I think I can make an argument to the zoning board that this relief can be met. It's very unique. It's one-off. It's FAR on the second floor, which I've yet to ever testify to. Typically attics, basements, or additions for FAR, a couple garage applications, but
Mr. Lewis, if I may add, I think Mr. Valerio's question sort of went to that issue. Because it's really the roof line that we're talking about.
Right.
Because
Yeah, the overall
they didn't,
footprint's the same.
so
Yeah.
the walls are the same. The foundation of the building is the same. The builder did not expand the foundation. But the roof line got made higher, sort of creating this.
Do you know,
The second floor instead of an attic.
I mean, essentially,
In
it
a
was
way,
almost
but
like a
it's on the
giant
second
attic.
floor, so you're, right, you would say, you'd think of, and this is Alex's point, you'd think of the, the attic, but he had to deal with 3,220 square feet. And he sort of submitted a plan, and then the roof line somehow got built a little bit higher. My clients thought that they could finish it out. But now without having to go through variance and this, my clients came to me, one of the couples moved from California, they didn't even know what a variance was. That's a great shame if you're a land use lawyer, but, right, so they're sort of innocent. So I think Mr. Valerio's point sort of got to, it's the roof line,
Right.
The change in the roof line is the delta that we'll have to show the detriment is relatively.
Yeah, and again, I don't
minimal to the
want to
board.
get into full variance proofs. I just wanted to get a little something on the record. Question, I don't know whether you know, were both houses given full unconditional COs? Were they still in on TCOs? Was it fully CO'd as, I guess, as non-FAR space because it's quote attic or?
Call them up. I think they, I proffered that. I think, one moved from Boston, one moved from California. They got their CO, they closed, they paid a lot of money to move into the house.
Is there some type of argument you're making that there was a reliance on the issuance of the approvals by the township?
We're not there, that's a legal argument, Counselor.
Well, you hear-
We're,
This is a legal application you make.
I would appreciate that. We could make that assertion. I don't know if we have to go that far. But there was certainly some element that my clients are innocent purchasers here, and there was a CO issued, and nobody informed them of this nuance about the extra 600 square feet. I think that's a reasonable assumption for lay people not to understand. So there was, a series of things happened that they didn't get informed, the builder, code department. Hopefully we can straighten it out.
They see that when they looked at the house? Did the resident see this condition when they purchased the house?
They knew the space was there, but they thought that they could do something with the builder, and there were negotiations with the builder to build it out further, but they didn't appreciate, and why would they, that they'd have to go get a variance, and They didn't
argue when
appreciate
you
that
aren't
step.
allowed to ask for a variance.
They didn't know that they would have to go get a variance because the house was built and a CO was issued. And there's an element of reliance upon the town's officials, I would suggest there's an element of that here at least, that if a CO gets issued and the building is constructed, that you don't have to go get a variance.
So it's a surprise to them.
Yeah, not only that they had to go get a variance because the space was enclosed, it was a bigger surprise when Mr. Wenzel, the Board of Adjustment attorney, kicked them out and said, there's a legal impediment, you're gonna have to go to the planning board. And this was 2 weeks ago, or less, 2.5 weeks, 17 days ago. About 17, 18 days ago.
So if they thought they could build the room out, which I take as truth, didn't somebody say, well, how am I gonna get to that room when you build it out? Was there an answer to that question?
I'll put my client on. Come on. Get him sworn and we're gonna answer your questions. You're gonna be under oath, so raise your right hand and counsel's gonna swear you in.
Raise your right hand. You swear the testimony you give in this matter will be the truth, the whole truth, nothing but the truth?
Yes.
Please give us your full name, spell the last name for the record.
Bhargav Modi.
Spell the name, please.
Bhargav. Last name is Modi.
Okay, and you have 23 Harvest Lane,
Correct.
and these were the pictures of your house. Alex, why don't you show us 23?
That's me, yes.
This is
Okay.
Mr. Modi.
Oh,
I was not as brave as.
Certainly can't say you didn't know that room was there. So, Mr. Modi, let me just ask you a couple of questions. So you went to see the house for the first time, right? And your realtor walked you through the house, and then did you see the open space the first time you visited the home?
If I may just take the liberty to just share the start to finish story, I think that might
Sure.
address a lot of the questions that were brought on here. But before that, thank you, Chairman, and thank you to the board members for your time and service today. My name is Bhargav Modi. My wife and I, we purchased this beautiful home in July of 2024. We got into the contract in about late March of 2024. The realtors that we leveraged were P1, which is the same realtor that the builders also represented as well. The house was at the framing stage at that point in time. We loved the location. We have a little kid, and today, right now, he's able to ride his bike, so it's dead end, so it's very safe. We liked the houses that the builder had built that we had seen. As the construction progressed, we noticed an area that was left unfinished. We inquired as to why this area is unfinished. Why can't this be finished? We were advised that this is beyond the scope of what you paid for. The builder is extremely busy. This will be finished at a later time to your liking for an additional fee. Of course, that was a little concerning to us. Our apartment was already re-rented. We moved in because the house itself is sufficient to us. After moving in, after various follow-ups with the builder and the realtors, we were finally connected with the builder's architect. Through designing this space to our liking, we got our hands on the original plans. When we were looking at the plans, we noticed the roof line was lower. We asked in a chat, where is the space being shown? We got a response back circling the roof line. We said, but this roof line is lower versus the actual is higher.
this is after you moved in.
Correct. We were advised, do you want to get this house finished or not? Well, you have the CO. There's nothing illegal has been done. We stressed it that, yes, we want to get this finished, but it's important that it gets done on a legal basis. The builder submitted the application as he had promised that he would finish this space out. To the zoning department or to the building department, we don't know exactly which department because we don't understand the process. 2 weeks later, we got an email from Michelle at the zoning office with a denial letter. That really took us by surprise as to why is this space being denied? What is this zoning? We came and visited Michelle. We explained to us what zoning means. It is at that point in time we distanced ourselves from the builder because we realized that something improper had been done here. We sought professional advice, and that's why we're here before you, seeking your approval to go ahead and finish this space out in a legal way.
You said you shared a realtor, so the realtor that was representing the seller was representing you?
Yes,
Did you ask the realtor, what's going on with the space in the back? How are we even gonna get there? There's no steps or a door?
yes, we were advised a door can be fitted there if you wanted to. We didn't want anything like that. Again, we have a dog, we have a little guy. We don't want them to mistakenly go into an unfinished area. As you can see from the photos, it's not safe for a toddler to be running around there. If you look closer, there's actually nails and stuff there too. We didn't want anything like that. We wanted this done properly after we moved in, as we were promised.
Did you have counsel when you bought it?
Yes, the council was also recommended by the realtor company. We were not advised of the legal impediment during the council's representation.
But we're not, just so you understand, we're not trying to give you a hard time.
I understand.
Somebody came before us and said, we want to take this one lot and make it 2 lots. And it wasn't big enough to be 2 lots. So we said, okay, we're going to let you make it 2 lots, but we don't want you to put giant homes on it. So you can't go and get McMansion ordinance variances, because that's what people would do. They would get a subdivision from us so they could have smaller lots, and then they would go to the zoning board and get a bigger house approved. So we started to say, if you're gonna file for a McMansion, you gotta come see us, because you already told us when you came for the subdivision, you weren't gonna do that, you were just gonna build houses that fit in the zone. So now, we're left in a very uncomfortable position because we don't have any teeth. We could put that in there all day long, and then very nice people like you, who just moved to our community, and welcome, by the way,
Yeah.
come into us and say, you know, I didn't do anything wrong, and you didn't, but we have no way, there's no way to police the situation going forward. If there's, just build it, and the planning board will let them, you know, fix it later. So it puts us in a very uncomfortable position. No offense to you.
And also to add to Mr. Santola's, what you said, well, welcome to Livingston, and we didn't intend to give anybody a hard time. But I think the dilemma here also becomes are we setting a wrong precedence? Will there be another builder who will make something like this and completely ignore or overlook the conditions that were set while the lot was divided, override it, and then present us a beautiful house? I mean, your house it's not of any detriment to the neighborhood. It looks fine as it is. It's not a big deal. It's not beyond the footprint, as council pointed out. So it's really not a big deal, but it's a matter of principle at this point. But again, now we're all trying to see what is the best way out and how can you be helped, is our intention. We're all neighbors at the end of the day.
We appreciate that.
So I'm going to weigh in and try and shed a little light. I may be speculating, but we have in our we recently amended it. There was a loophole, if you will, in our FAR and habitable floor area ordinances that created an exception for subsequent conversion of attic space within, if you're not changing the exterior, you can convert an attic and it doesn't impact, you don't have to get a variance. That no longer exists in our code. It existed at this time. My gut tells me that Mr. Rodak, who's built in town and knows that ordinance, probably fully expected that he'd be able to comply with his planning board because he wouldn't need a variance because we had an exception for it. And now it requires, because that's no longer in the code. So that, I think that's probably how we ended up here today. And I see he's nodding in the background.
I think the problem is, builders would use this loophole as an exception. They would use this loophole as an exception, and it came time to stop it. And I guess this is now getting caught in that,
The closing of the loophole came after.
Change.
We appreciate that.
Which your client has nothing to do with.
That's the issue that I'm
Right, your client has
requesting
nothing to do with.
that the equities be balanced. This is not, and I think it would look a lot different if this was a builder before you tonight, Because a builder had come to you, secured the subdivision approval, and then built something, and that same builder said, oh, oops, I made a mistake, please change that condition. If I was representing Rodak and Rodak sitting here. Here, we have a builder submitted construction drawings with a roof line and didn't build that roof line.
Yeah, this is actually.
And this went through, there has to be, please, some recognition of some degree. We don't have to decide whether the culpability of the construction department is 1 or 10 tonight, but
So,
it's such a very difficult situation.
I guess the added insult here is that, number one, trying to use, using the loophole, but number two, building not according to the plan. We have too little.
I absolutely agree with that. So, yeah, I think that last statement is what is hitting me. And in fact, that's the crux of the problem here. The approval was done, as Mr. Santola said. By the way, welcome to the town, to yourself and the Sony family. You shouldn't have this experience. Believe me, it's a beautiful town, and we do a lot of good things in town. But to Mr. Santola's point, when this application came, subdivision happened, conditions were set. Rodak Builder is not new to town. Loophole or no loophole. There is a way to work through what is approved and not over-construct. That's actually very, very, disappointment is a very, very soft word, to say the least. So not a issue for the buyers, we understand that. But there is absolutely an irresponsible part, the way it is constructed. And the way it is sold, so I think that is where we were going, is that how it was sold to you. Again, loophole or no loophole, it should not have been constructed, that's number one. And now it's up to us to really see through what other arguments are there.
That's why I opened it, it's unusual, so it's constructed, sold, and there's another verb called approved.
right, and that's, certainly as the town manager who oversees the construction office.
You might have taken tonight's meeting off,
I
right?
have some concern about what happened, and
Right.
certainly, if plans were submitted, it was built with a second story instead of a first story, and we went out there and CO'd it, that's a problem, right? Because that's where it should have been caught. It wouldn't have been conveyed to your clients yet. We would have gone to the builder and said, take that floor off or
I
something.
absolutely agree there too.
Yeah.
So
Barry,
it's
can I ask you a
really-
question? You think that would have qualified as an attic under the
Well,
old? I mean, I don't know how they determined what an attic was, but it had windows and
It's
full floor height, right?
Switches.
may or may not have been a
becomes a
stretch.
practice.
I have to tell you,
Yeah.
because we kind of all know the facts now, and we should talk about this. I think Mr. Skolnick's last argument is a winner for me. When the facts aren't in your favor, you argue equity.
Yeah,
And he
No,
says
and
the
I-
person sitting next to him did nothing wrong.
100%.
We gave a CO we should have never given, and I don't know.
It would have never closed.
how it's fair to
This
do
would have been
anything
caught
else.
before
Well,
that.
let me just,
And I, so,
can we find out why this was built this way?
Yes, I would agree.
I mean, I would like to find out, and
Yeah,
I
that's
don't,
what
but
I-
I don't know that that's, well, I mean,
not
I don't know
gonna
that it's
resolve the
necessarily relevant to these folks, but, so my understanding is when there's a valid condition in a planning board resolution, which there is, our ability to change it largely hinges on either changed circumstances or other good cause. The changed circumstances that it was built, I don't know how much equity
You
there
can't
is
make your
that.
own circumstances.
You can't create your own changes. But the other good cause, I think, is where the combination of the innocent buyer, whatever dropping of the ball by the building department, COing it, all to me comes together. So I'm leaning towards, but I'm going to qualify it in the sense that we put that condition in there to limit the size, given the fact that we were allowing 2 undersized lots. I don't think it's an all or nothing. I don't think I think there may be a way to modify the condition to permit this deviation, but not future deviations. So they don't come back to the Board of Adjustment 2 years from now and add another 500 square feet, because there's no equity on it. But that's kind of where I'm coming down on it.
That seems to be reasonable.
I think that makes good sense, Barry.
I just want to say on the record, it's a beautiful home.
No, they look nice, they're good rateables. Cha-ching.
It's a beautiful home, and the value of this space can only add more value to the site, and which is otherwise adds value to that neighborhood. It's
And
it's
you
a
can walk
beautiful
the
home.
Bottle King.
It's my Friday pit stop, yeah.
On
my own.
on that note of beautiful,
What
isn't that a
section
little
of the
bit?
municipal land use law is that, Mr.
So,
Spatola?
on
You
that,
couldn't put a
uh,
church here.
Is that one of the goals and purposes of zoning in section 2? Being
Air
able to
and
walk
light.
to the liquor store?
Question for you. In the note of being beautiful, I mean, and that if you show that picture, isn't it odd to not have more windows?
Right, that was my first comment, anecdotal comment to the applicant when I saw it. I mean, I'm in people's homes a lot. I see homes. I personally visit every site I testify to, new construction, additions, that kind of thing. I testimony across state. I can't recall a home I've been in where the rear wall does not have a window that looks out. That was, and I'm looking on the first, I was going up and down the stairs. I'm like, wait, so it stops in the middle here and there's a space here? And he's like, yeah. And I'm like, well, how do we get there? And he's like, I should show you to go up. And so I was just eager. That's why I dropped down. I'm like, oh, this is a huge space, and I just said the same thing. I'm concerned if I was a homeowner, the windows, what happens if something happens back there, you can't get access back there. And I was like, and so we came with the architect, and the architect made some reference about windows and typical architectural designs. But I do find it weird that we have that. It's considered like a faux window. It's a fake window. You can never bring that light in. I will say, when dealing with 23 Harvest, Mr. Modi, his proposed application, one of the concepts in that back area was a beautiful sunroom. It gets a lot of sunlight in that rear yard. I was like, yeah, and the windows are fairly large as well. But I felt it was weird that you have a window in the backyard, and then when you're upstairs, you didn't see that window. So it took me a while to get my bearings when I was in there to figure out exactly what he was trying to describe to me, because, again, I've never seen something.
Well, it's
like this.
probably more consistent with trying to at least initially treat it as an attic by not having windows.
But you can't get there from the attic unless you jump down there.
They're considering
Yeah.
that part of the attic, is
Yeah.
my guess, but whatever.
Yeah.
But even if it is an attic, it will still be a violation.
It is
of
now, but 2 years ago, you could come in, convert the attic, not need a variance, because that was the loophole we talked about. So he wouldn't have needed to violate the planning board condition because he didn't need a variance.
I don't have the definition of an attic in front of me at the moment, but I would argue that this wouldn't have been an attic. It's on the second floor.
Yeah, that's what I was gonna say,
Yeah,
it's
but
under
I'm
the
just
attic, you went through the
Yeah,
attic and you jumped in.
and dropped down, yeah.
No,
It's not
That's
an
what I gotta
attic,
figure
yeah.
out how we CO'd it.
This is
Well,
the,
Barry, I would, I might agree with you, but this wasn't built that way.
No.
It was
It's
built
not
even
an attic.
bigger than that.
It was on purpose.
Right.
Irresponsibly built.
I can't say it was on purpose or not. Things happen on the job
okay,
site,
we got it.
but
We're, I have a client and we're asking the board to weigh the various equities, including, its own authority to impose conditions and make sure those are satisfied. We absolutely appreciate that, but this is, I think, a real one-off here in terms of what occurred, who was responsible, and also a situation, not on the merits, but the board could consider, there is a very large backyard here, and the massing is only in the back, so we don't have some of those other concerns that perhaps the board had thought about when it imposed the restriction. Now we have a constructed house, it could see actually what's going on, and I think that could be at least a little bit of a factor as well.
So I just want to throw this out to the board. I mean, I think we've heard a lot of testimony. Do any of the board members have any other questions? Are they prepared to, to make a motion one way or the other?
Again, I think all things considered and under specifically the other good cause component to modify or rescind a condition, I'm not inclined to fully rescind the condition, but I'd be in favor of modifying the condition to allow the FAR and ratio exceedance to whatever the number, I don't know what the numbers are. You can provide us with the numbers so that it can go in the resolution if
No,
that
I
would be my
would be
motion.
careful about making any type of opinion as to the FAR. All you're doing is allowing them to go to the zoning board to make their case. We're not allowed to give
We're not
FAR.
granting it, no.
Ratio, we can't do anything
No, I'm
about a
just-
ratio. It's not jurisdictionally allowed.
No, I'm just saying revise the condition to have, they'd still have to go get the variance. We're
The
not granting the
current
approval.
as-built condition.
Right,
You're saying you don't want any more additions to what is currently there?
exactly. I'm sympathetic on this one, but I don't want to open the door for them to come next year and add more. or
If you
pursue
look at the
another
house, I think
variance.
that'd be pretty unlikely, but it solves the,
Yeah.
that would solve this element of the problem. And perhaps Mr. Valerio could draft something, maybe I'll take a look at it in terms of what that might look like.
Mr.
Well, that's
Lewis,
my motion.
Mr. Lewis, I have a question for you.
Yes.
So while we close the door on this application or this particular property not coming back with any further increase or enhancement or built up, how do we close the door on any such future case with something similar, some similar storyline where this happens, over construction without permission, and then the home purchaser is in a limbo, and then we want to help. And then this goes down in history of our planning board saying that, okay, this happened in so-and-so year with the so-and-so application, thus.
Yeah, well, I don't think legally it's not a binding precedent in the sense of, because each case or matter before us, this is relatively unusual, given that it was already built, CO'd. Again, as far as closing the CO component, that's on me and the building department, the planning department, and how this got CO'd, not the planning.
Things
Throw
happen in
Jackie
life.
under the bus. She had nothing to do with it, the building department.
Things happen in life. We're not, it's not our issue exactly, but things do happen. We appreciate that.
Yeah, this would not have happened but for the CO, which allowed the property to close, which allowed the innocent purchasers to buy it, which, again, we issued the CO.
So we have a motion, is there a second? Is there any further discussion? Jackie? No, Sam?
Yeah, based on the facts, I don't think we have a choice. I feel for you to go into a new home and try to enjoy it and have all this complication. So I think we, as a group, hope it works out for you. Thank you.
Thanks, Sam.
And
Jackie?
welcome to Livingston.
And now that you are in Livingston, hope you'll volunteer your time and.
Got a lot of committees.
Jackie?
All right, there's a motion. Mr. Lewis?
Yes.
Mr. Ratner?
Yes.
Mr. Dufford? Mr. Batani?
Yes.
Ms. Vishnu?
Yes.
Ms. Khanna?
Yes.
Vice Chair Santola?
Yes.
Chairman Fernandez?
Yes.
Thank you. Motion carries.
Thank you, Chairman, members of the board.
Thank you.
Ms. Khanna, it's usually the other way around, of course, right? I'm sure you've heard applicants, I've coached, I volunteered, I did this, so please give me the variance.
Great, I've lived here,
right?
lifelong resident.
Now we have this is the first time I've ever heard, now it's all switched around. We'll give you the relief, and then please coach. We're good. So there you go.
All right,
Thank you for
with
your
that,
time.
we are adjourned. Thank you.
He even took a video for us. What is down there?